Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Intan Syafiqa Binti Abdul Salam and my matric number is 1201584. So, today I want to present case review in the case of Muhammad Zaiman bin Jarmin versus Nur Asia binti Majid. First of all, what happened in this case? The plaintiff and the defendant were married on 20 August 1997 and they had 3 children who are Muhammad Zulkifli, 9 years old, Nurul Asmaniza, 8 years old and Muhammad Zulhairi, 6 years old. However, due to certain circumstances, they were divorced on 7 July 2005 and the children under the care of the plaintiff. Based on their mutual agreement made before the conciliation suluh officer and recorded by the court, the plaintiff was ordered to pay a sum of RM450 per month as maintenance for the children, which covers all the school expenses, clothing, food and so on. The payment had to be made to the defendant by a salary deduction of the plaintiff. Therefore, the plaintiff asked for permission from the court to vary the order by reducing the maintenance to RM250 per month. On the other hand, the plaintiff, who worked as a production operator, earning a net sum of RM847.03 per month, contended that it had become difficult for him to secure overtime work and this had affected his income. We move to the next part. The parties involved in this case are Muhammad Zaiman as the plaintiff and Nur Asia binti Majid as the defendant, and also their 3 children who are Muhammad Zulkifli, Nurul Asmaniza and Muhammad Zulhairi. There are 2 issues that I found in this case. Firstly, whether the court has the jurisdiction to hear and decide the case. Secondly, whether factors considering in determining appropriate amount should be allowed by the court. According to Section 61 Clause 1 of the Administration of the Religion of Islam Enactment State of Selangor 2003 stated that a Sharia High Court shall have jurisdiction throughout the state of Selangor. And Section 61 Clause 3 also stated that the Sharia High Court shall hear and determine the proceeding if the parties are Muslim and related to the maintenance of dependents. Next, in Section 62, Clause 2 in the same enactment stated that the Sharia Subordinate Court shall have the jurisdiction to hear and determine the proceeding if the amount of the subject matter in dispute does not exceed RM100,000. Therefore, based on this provision, the court has the jurisdiction to hear and decide this case which related to Islamic family matters, including the maintenance of the children. For the second issue, the court referred to Section 73 and 74 of the Islamic Family Law Enactment State of Selangor 2003, which has mentioned about the duty to maintain the children, while in Section 76 in the same enactment has mentioned about the power of the court to vary order for custody or maintenance of a children. In this case, the court considered that the ability of the plaintiff to maintain the children to be more prioritized over the needs of the children. Next, agreement by the parties. The plaintiff, who worked as a production operator, earning a net sum of RM847.03 per month, including allowance in March 2007. The plaintiff contended that it had become difficult for him to secure overtime work and this had affected his income. He also informed that he had quit his job. Therefore, he is seeking permission of the court to vary the order by reducing the maintenance from RM450 to RM250 per month. In this case, the court held that the plaintiff, Muhammad Zaiman, was responsible in providing the maintenance for the children because they were all still schooling and would require expenses for their needs from their father. In determining the maintenance, the financial standing or means of the father is a more critical factor to be considered than the needs of the children. However, a sum of RM250 for maintenance of the children was considered too low, but the court was convinced that the plaintiff was having financial constraint and thus allowing his application. Therefore, the plaintiff was ordered to pay maintenance for the first and second child, a sum of 120 ringgit per month for each children, and for the third child, a sum of 19 ringgit per month, and had to be made to the defendant bank's account. In my opinion, I do agree with the decision made by the Sharia High Court, which is such a good decision since the plaintiff has many deductions from his income, making him difficult to pay maintenance for his children, where the court reduced the amount of 330 ringgit per month in view of his employment and income status. Based on the case above, it clearly mentioned that the plaintiff, Muhammad Zaiman, was responsible in providing the maintenance for the children. In Surah At-Talaq has mentioned that let a man of wealth spend according to his means, and Allah does not burden any human beyond his capabilities. However, the maintenance of the children cannot be deferred since it involves their basic needs, and if the payment made was delayed, it will cause injustice to the child. And I think any resolution which regards of family matters or family dispute through mediation and suluh is more better than a litigation process.